My Lords, may I congratulate the noble Lord Woodley on the tenacity that he has shown in continuing the fight against the injustice of the IPP sentence. The noble Lord the Minister will understand, I hope, that the amendments in this group are intended to be helpful in that they offer the government a range of possibilities, flexibilities about the application of resentencing in the event that they cannot bring themselves, and I think it's clear they cannot, to endorse the recommendation of the Select Committee in the other place in 2022 that all prisoners subject to this sentence should be resentenced, and the solution to the problem lies in that. So that is certainly the character of the two amendments standing in my name, numbers 11 and 12. They make a point that was often made, in fact, by the late Lord Brown of Eton under Heywood, who was so passionate about this injustice. Namely that in July 2008, there were significant reforms, as the noble Lord Woodley has already said. There were significant reforms to the IPP regime in England and Wales through the Criminal Justice and Immigration Act 2008. And these changes aim to address the growing concerns about the sentence. And the changes were that a seriousness threshold was introduced, and from that date an offender could only receive an IPP sentence if the offence they were being sentenced for was serious enough to justify a determinate sentence of at least 4 years. Before this change, there had been occasions, some referred to in Parliament, some are anecdotal because the names are not always known, of people with determinate sentences, implied determinate sentences, as low as 28 days, who had been given IPP sentences. From this point on, 4 years was the seriousness test, and this was a major shift. And the reforms also gave greater discretion to judges, allowing them to do their job properly, that is, of sentencing somebody according to their individual deserts, which is the purpose of the sentencing regime. The Criminal Justice Act 2003, the original act, had not given judges that discretion. It had said that they must assume that there is a risk in the cases of those qualifying for IPP sentencing. They must assume that there is a risk unless the court considered that it would be unreasonable to conclude that there wasn't a risk. And these are very strong words. Must and unreasonable set a very high bar, effectively removing judicial discretion in making the in determining the sentence. And the defendants sentenced under this provision were denied what should have been their right to an individually appropriate sentence. Now, the key point, as the noble Lord Woodley has said, is that these changes that were made in 2005, which came into effect on the 4th of April 2005, only related to offences committed after that date, the 4th of April 2005. There was no attempt to make them retrospective, and that people in prison, July 2008, only came into effect from July 2008. And there was no attempt made to make them retrospective to those who had been sentenced between 2005 and 2008, and many of those people are still subject to the sentence. Many of them are in prison. Many of them have never been released. They're amongst the 1,000 or so IPP prisoners who have never been released to date. They continue to suffer from an injustice of exceptional gravity. They're serving a sentence which was recognised in 2008, was passed pursuant to too wide a serious threshold, and by a judiciary whose discretion Parliament had so fettered as to prevent them from saving defendants from unjustifiable severity. There are two amendments, 11 and 12, because one is required for IPP sentences and the other for DPP sentences, the sentences imposed on those under 18, as the noble lord has explained, because that is the way in which the legislation is drafted.